Good morning. Please take your seats. Call the meeting to order of the Texas Real Estate Commission at 10:05 on this, whatever day, 10th day of February 2014, and ask Commissioner Westcott to lead us in the pledges of allegiance. Please rise.
Please join me in the pledge to the American flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Now the Texas pledge, please. Honor the Texas
flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
You may be seated. We have received notice this morning that Commissioner Alley will not be in attendance. I would entertain a motion to excuse his absence for personal reasons.
So moved, please.
I have a motion. Do I hear a second? All in favor say aye.
Aye.
And opposed, nay. Motion carries. It is at this time that we every year elect our officers. We have the seat of secretary, which has quite a bit of work these days, and Vice Chairman open, and I would open the secretary position for nomination.
Madam Chairman, may I nominate Joanne Justice for the position of Secretary of the Texas Real Estate Commission?
I have a motion. Do I hear a second?
Second.
Second. Is there anyone else who would like to make a motion at this time in that? I think you're going to get it, Joanne. All in favor say aye. Aye. And opposed, no. Joanne will take that job, and we appreciate all you do, because now that we're online, I know you have to watch the video and make sure that everything is timed right. So she doesn't get to just sit through it, she gets to watch it again later. That's why no one wanted to be nominated. And I would open the seat of Vice Chairman, seeking a motion.
Madam Chairman, I move that Bill Jones be appointed to the position of Vice Chairman.
I have a motion. Do I have a second?
Second.
Is there anyone else? Any other nominations?
I'm sorry, I thought we were voting.
Oh, okay. All in favor say aye.
Aye.
And opposed, no. Congratulations, Commissioner Jones and Justice. Yay. Whatever. At this time, we also do generally committee appointments, and I do have a speaker on items C, D, and E under 4. So since I have no one requesting an opportunity to speak on A, I believe that we would reappoint the Budget Committee of Weston, Martinez, Troy Alley, and Jamie Hensley, and add to that Commissioner Turner as well. So everyone's okay with that? I'm going to move forward with that. And in the Enforcement Committee, we would have Commissioner Arriaga, Turner, and Jones on that committee. Now, the person, Mr. Carpenter, who wishes to speak on the liaison position for the Inspector Advisory Committee, Mr. Carpenter, would you come forward? You would have 3 minutes to say what you wanted to say. Mr. Carpenter.
I'd like to waive that at this time.
Okay. Then without any other comments, I would appoint Commissioner Jones as a liaison to the Inspector Advisory Committee unless someone else wants that job. No. Okay. Mr. Carpenter, you also waive the other 2 comments on D and E?
At this period, yes, sir.
Okay. Good deal. So if that works for you, we would ask Commissioner Justice to continue to serve for the Advisory Committee for Education Standards, and Commissioner Jones for broker responsibility, unless somebody else has a burning desire to serve and come back to Austin for all those meetings. Seeing none, those appointments will stand. So now we would anxiously look forward to the reports from staff. One more? I did that. You weren't paying attention. Yeah. Mr. Olmixon, are you going to be up first?
Yes, I.
Okay.
Good morning, Administrator Douglas Oldmixon. Thank you all for your continued service to Texas as members of this important policy-making body. It is winter, and the old man has played havoc with the agency the past few weeks. We've been closed for 3 days because of ice on local roads, but your staff is working hard to make up for lost time and to provide the level of service that our license holders have come to expect from us. I have the great pleasure of welcoming and introducing to you today Miss Kristen Warman. Welcome her to our team as the new TREC Deputy General Counsel. Her other primary responsibility is as General Counsel and Deputy Commissioner for the Appraiser Licensing and Certification Board. So welcome, Ms. Warman. She comes to us, her most recent assignment prior to finding the promised land here was at Texas A&M. Last October, the agency staff participated in the State Employee Charitable Campaign, and I'm pleased to tell you that we set new records and were recognized for achievement in 2 categories. For the highest average gift per member, over $162, and for the most improved campaign, increasing our participation by 68%. So, there we go. We're very proud of these achievements as they reflect the generous spirit of your team. Your staff members are also completing the University of Texas sponsored survey of staff engagement, and we will provide that final report to you. It's an annual process that we go through once we have received that. We've also begun the process of strategic planning, and I'll give you more details on that process later in the meeting. We have reviewed the interim charges issued by both the Lieutenant Governor and the Speaker, and are pleased to inform you that there are no topics that we need be directly concerned with as a commission. On the examination front, we completed 2 exam reviews, both for real estate license holders and for inspectors with our vendor, PSI, and we have the results of our current request for proposal, for which we will be making a recommendation to you later in the meeting as well. Rule review is fully underway, and your agenda today reflects some initial recommendations in that arena. Several staff members and our chair spoke to the Texas Association of Realtors winter meeting this past weekend, and the information and presentations were well received as this important collaboration continues unabated. In April, Arello, the Association of Real Estate Licensed Law Officials, will meet in San Diego, and we will be in attendance to both learn and to influence important regulatory progress across the nation and beyond. On a personal note, I'm happy to inform you that I was appointed to a 3-year term to serve as a trustee for the Arello Foundation, the charitable arm of this global organization. Last meeting, I reported to you that the recovery fund was perilously close to the level at which the Commission must authorize an assessment of license holders to replenish it. The good news is that this situation is not as dire as we previously thought. One category of assets inside the fund was not properly included in the total reported last time, but this error has now been corrected, and you will hear from our CFO that we are in better shape to the tune of about $500,000 than we previously thought. Thank goodness. Let me personally apologize to each of you and to our license holders for any undue alarm. Lastly, on a sad note, but one that will come for each of us at some point, this will be the last meeting for the Commission's long-serving recording secretary, Pat Holder, who will be retiring before our next meeting. We wish her all the best as she moves into this next stage of life. Pat, thank you for your many years of service. Let me also introduce our new recording secretary, Amber Hinton. you can expect the same level of professionalism from Amber that we received from Pat for all these years. So Amber, welcome. And so I'm happy to answer any questions you may have of me. Otherwise, I'll turn it over to your senior team of division directors for their regular staff reports. Are there any questions from commissioners?
Any questions for Doug?
Okay, thank you.
Mr. Olmixon. So our first reception and communication, Ms. DeAnda.
Good morning, Lori DeAnda, Director of Reception and Communication Services. If you please refer to the C1 report. For the month of December, we handled 12,631 calls, bringing the fiscal year-to-date total to 59,318. We assisted 361 walk-ins, bringing the fiscal year-to-date total to 1,718. And we responded to 3,540 emails, bringing the fiscal year-to-date total to 17,524. And I'm available to answer any questions.
Mr. Commissioner Arriaga.
I'm impressed we get 12,000 calls a month.
Yes, sir.
Did the CCIM math, and that's about a minute and 15 minutes per call. Are we keeping track what the calls are about? Is there a majority amount of calls on a certain theme?
The majority of the calls are with online renewals or the RMT, where we're assisting the change of sponsorships. That's the majority of the calls.
It's not complaints or concerns, mostly just information on how to complete the forms.
Correct.
Are the forms that difficult?
The forms? No, sir. The majority of the calls, they're needing assistance to get into VO. They're needing assistance with their passwords, things of that nature.
So is access a problem?
Sometimes. Not all the time, but we do have some issues where they're needing assistance getting in.
Because maybe the knowledge of using the internet is not that much, or maybe our system's too complicated.
Sometimes we have issues with passwords. They may not receive them, or they're just needing assistance on how to get in.
We're doing excellent work but at the same time, it's a lot of manpower of time. So I'm trying to streamline the process to make it simpler, so you don't have to spend a minute and a half per person.
Right.
I think a little later on you'll hear maybe an update on some technologies that are in process that may make the online process a little more streamlined and hopefully cause the people who have to call to be people that aren't just trying to figure out what their password is.
I've never had a reason to call in. Everything happens just maybe because I'm special or treated
It's
special.
okay. Yeah, that's they have your phone number tagged. Yes. Mm-hmm.
Thank you, Ms. DeAnda.
Okay, thank you. Any other questions? Okay, thank you.
Just a comment, if I might, Commissioner Arriaga. For quite a few of our license holders, the time that they spend actually in the password-protected part of our website is only once every 2 years when they go online to renew. And so while we do have a password reset capability, it's quite often they've simply forgotten either the username or password, or they have changed their email, and then the course of the reset sends the new password to their old email, which they may no longer have access to. And so it's just a manual process of updating the record for them so that we maintain account security. But that's a large number of the calls that we get.
Thank you, sir.
And I think blessedly, if you will, the fact that license holders don't have to come to us to our website frequently for other things, it's not all bad that they only come once every 2 years.
Ms. Jackson.
Good morning. Gwen Jackson, Director of Education and Licensing Services. If you would please refer to the L1 report, which is the Education and Licensing Services Division numbers, totals on applications received, licenses issued, and renewal activity. As you will notice, we have an increase in total original applications. The majority of that increase, of course, is through sales original applications that we received. There was a over 110% increase in volume from that of last year, December 2012, from December 2012. Now, while this is a significant increase, please keep in mind that 2012 numbers were below average for sales applications. Recall that the education requirements for a sales license changed just prior to fiscal year 2012. So basically, we had a high volume of applications that were filed during fiscal year 2011, which resulted in a lower volume of receipt of applications in 2012. The report also reflects a 113%, well, I just discussed that, 113% increase in licenses issued from original applications filed. I'm sorry, there's a 13% increase, not 113.
Okay.
Okay, a 13% increase in total licenses issued from original applications. And our renewal activity remains steady, with over 89% of our brokers renewing and 82% of our salespersons renewing during this period. Any questions on this report?
Any questions? No.
If you will now refer to the L2 report, there you will see that we've had an increase in total brokers and sales. In 2012, we had 138,582. In December of 2013, there were 144,448, which is an increase of about 5,866. That's reflected also in the number of sales licenses, where we had an increase of 5,839 of total sales licensees from that of 2012. We remain fairly steady with the number of brokers that we've got. And if you will also notice that we have more licensees who are choosing to become active. And we have a total, and this is I think this has been the highest that it's been in quite a few years, of all licensees and registrants of 149,417, whereas in December of 2012, there were 143,881.
Madam Chair,
Yes.
is
Mr.
there
Arriaga.
a fee for being inactive?
Yes,
What is it?
$20.
And is there
No,
much
to
work?
become, did you mean to become inactive or to remain inactive?
Both. Just,
Okay.
if you carry one for inactive for
The
10
fees are the same whether you are active or inactive
per year,
per year.
and what do we do for them? Just store them, and we don't,
We
there's no employee work for the inactives?
That's correct. They may not practice, but they pay the same fee for the privilege of remaining grandfathered on their requirements. If they were to allow their license to lapse, then after a period of 2 years, they would essentially have to meet all the new requirements.
Got it. Thank you.
If you will refer to your L3 report, our year-to-date results for our examination activity are that the first attempt pass rate for salespersons was at 58.5%. First attempt pass rate for brokers was at 53%. It's 33% for real estate inspectors and 58% for professional inspectors. The L4 report
Ms.
provides...
Jackson, we have a question, Commissioner Arriaga.
2012, 11, and 10, have the passing rate gone up or down? Is there a trend? Have we redone the exam and made it harder? Or have we made it easier and we got superior instructors? What's the
For
trend?
which category?
Well, brokers and sales.
For brokers and sales? Brokers and sales remains pretty much the same.
I thought we went down in terms of passing rate.
You think 58 is less than it was earlier? Is
That's
that what you're
correct.
saying? No.
I can tell you that in 2009, the blended pass rate for both, for both brokers and sales was right at 55%. So that while there has been a slight increase over that period, we actually do have the statistics and could provide them to you on a year by year just to see that trend. But in general, it has remained fairly flat.
So only 6 out of 10 passed the exam the first time,
The first time they try.
and basically the second time also,
No, the applicant pass rate is the next line above that.
80%.
So once they take the exam for a second or subsequent time, generally somewhere between 82 and 86% pass.
Is there a cost for taking second exam?
It is the same price as taking it the first time.
Got it.
Okay, Commissioner Martinez?
Madam Chairman, I'd like to ask that on this report going forward that we have at least 2 years of historical data provided.
We can provide.
So in
yes.
this case, next quarter, if we can have 11 and 12 just be there, so that way we know what it is. It'll help us in some of our other questioning.
Yes, would you like a comparison, a year-to-date comparison of what it was in the previous year?
Trending?
I think we can do the math on that if you just want to say what it was for like 11 and 12, and we can see if it went up or down. Thank you.
The next report that you have in your package is the instructor distribution report, which indicates that we have a total of 5,532 approved instructors as of December of 2013, which is fewer than we had in December 2012. We were at 5,095.
Madam Chair,
Yes, sir.
in order to become an instructor, do you need a real estate license?
Yes, you need to have 5 years professional experience in the subject areas that you're going to teach or have been licensed for that period of
Do
time.
they also have fingerprinting,
Not for the instructors.
any background checks for instructors?
Yes, background checks, yes,
But no fingerprinting?
but no fingerprinting.
Thank you.
Any other questions for Ms. Jackson? You conclude? Thank you. Mr. Moore?
Good morning. Mark Moore, Standards and Enforcement Services. I'm the director of that. I've got 3 reports today, but first we wanted to introduce a new employee. I'm not sure where Pim Mayo is sitting. She's a new lawyer with the division.
All right.
Pim's been with us a few months, and she last was working for the Railroad Commission, and we're really happy to have her. First report is the case status report. In general, I look at the number of cases we receive versus the number of cases closed. We had a really high number of complaints received for about 4 months ending in October, so we're a little bit concerned. November and December, that dropped off significantly, so we're able to make up some ground, and we're pretty much about even on cases. Our short-term goal is to close more cases than we open. I realize that's an impossible goal long-term, but that still is our short-term goal, and we're about even right now, so we'd like to close a few more cases, and it's certainly what we're looking for. Any questions on that report? The next report is the open case aging report, and we have about 90% of cases are less than a year old. The cases we get most concerned, of course, about are the cases that are over 2 years old. We have 7 cases over 2 years old. 5 of them are being heard today. They've been already been issued proposals for decision, so they're here for consideration by the Commission on final order. And then 2 other cases, we've issued what we call a notice of alleged violation, also known as an NOAV. At that point, the respondent will either accept the NOAV or not respond at all, which would be a default, or they request a hearing. So that one is also moving along, another 2 old cases with the same respondent. Yes? Oh, I'm sorry. You recognize that. Sorry.
Question, on the 18 to 24 I know we've got some in there. We're going to have those resolved, or are we going to have to see those move over into the other categories?
I'd like to see them resolved. Sometimes they move over, and I actually meet with every attorney monthly to go over cases that are getting close to 2 years old. I think they're flagged for me at 21 months old, but I also get concerned about any cases over a year, so we do try to get those set and moving along. But some of those will likely move over.
What's your gut feeling? Do you think we'll have?
On those 18 to 24 months? Some of those will move over. I'd like to see that number in the 2 years. I mean, I'd like to see it go away completely, but I'd say five of them might move over. Maybe more, and I'll be apologizing then.
No problem. Thank you.
Any other questions? All right. Next report is the pie chart. Pie charts are great because they pack a whole lot of information into just a graphical form. This report is already getting popular. We've used it in a couple presentations recently, and there's a lot of interest in it, and I think it gets more valuable as we get more data. There's usually not a lot for me to comment on unless I see a lot of trends or something significant happening, which I don't see right now. These are kind of the numbers we expect. Or any questions on this report? If you look at the next page, there's also a breakout of data. So that actually shows you, and I think this is really critical, where you see sort of the significant change in data from month to month, which is why aggregating it is so important to make it useful. All right, Nate.
Commissioner Arriaga.
Counselor, it seems like 25% of the concerns are salespeople, and that's why we did the broker's responsibility course, because someone needs to keep track of what's going on. But the other almost 20% is on leasing and management. Maybe at some point in time in the future, we ought to look at if anybody wants to do management or leasing, and as we know, during executive sessions, 80% of our concerns are people that are not following the rules, which means we're not properly training them. So there might be a course necessary if someone wants to do leasing or management, and make it a specialty also, because it's costing us a whole bunch of money. And we'll see that today, that every time someone messes up, the state has to ante up. Not only the state, but the real estate professionals in the state of Texas. We need to consider looking at that in the very near future, Madam Chair.
Commissioner Arriaga, just for your information, I don't believe this is on the report later on, but the Real Estate Center and the Commission are in the process of regrouping the broker responsibility writing group, creating a new group, and the plan, at least orally, that we have discussed is adding a significant amount of more information into broker responsibility about property management issues. Now, I know that's just one little tiny thing that we're doing, but that is one little tiny thing that I haven't had a chance to tell you.
I would go as far as make it mandatory, because we don't do property management. If we did, it had to be someone that's really specialized.
Commissioner Jones.
And there's a little bit of a scenario of whack-a-mole that goes on here. We take emphasis and put it on the complaints and the things that in the education that happen, only to find that the new infractions are entirely in a different area. The example that I'm dealing with locally has to do with the Service Members Civil Relief Act, which is something that I don't think I've ever seen taught before, but yet we're seeing some abuses in that area. It's a strange moving target.
But leasing and management has always been a big cost to the state of Texas, because people
sure.
Thank you, Madam
Thank you. Thank you, Mr. Commissioner. Mr. Moore?
I have nothing
You're
further.
done? Any other questions for Mark? Thank you.
Thank you.
Mr. Watson?
Good morning.
Morning.
I'm Tom Watson, Director of Information and Technology Services. On page 22, the I-1 report, we are showing some really strong numbers on the online services. We continue to see that renewals are strong, and actually from a strong base, they have had good results in this past winter and fall. The applications, however, we've shown really good progress on, and good numbers at 73% utilization of the initial applications over the past year. So that's a very positive sign. On the following page is trending over the last 12 months, and again you'll see a defined pattern on the initial applications showing positive utilization of that particular service. With that, I'll be happy to answer any questions you may have.
Commissioner Arriaga?
Mr. Watson, we had long transition switching from the old system to the new system. And we had concerns on certain hardware as well as software. Has everything been panned out? Have we paid off completely the vendor that set up the new system?
We have paid all the initial fees, and we continue to renew our maintenance and support agreement with them. The hardware is paid off. So from a vendor standpoint, they're really only providing, at this point, services, support, upgrades, that type of service. And the hardware is our responsibility, of which we manage.
I guess the question is, are we 100% happy with the new system?
I think that the performance of the system is improving. I think that it still has some areas to continue to improve upon. We continue to work with the vendor on those areas and try to emphasize, I guess, our areas of concern. But you know, they've made some changes in trying to reallocate some resources for us and dedicate some resources specifically to our particular needs.
But you're comfortable?
Yes.
Thank you.
Thank you, Madam Chair.
Commissioner Martinez.
We talked about a technology update. Is that happening later, or is that also?
I was going to ask Tom if he was ready to talk about any kind of website stuff going on.
We continue the website project. We, at this point, have gotten some design elements in place for the new website. We are working on the infrastructure at this point and putting together the technical aspect of the servers and the tools to manage the presentation of the website. At this point, we are looking at the TALCB as our initial rollout, and then TREC will come following on, utilizing many of the things that we have put in place for them to expedite the implementation of the TREC side. So it is an active and top priority project for us.
Did you have another question, Mr. Commissioner Martinez?
I do, but I'll let Commissioner Jones go
Mr.
first.
Jones?
I just wanted to congratulate you and thank you for this relationship management tool. The folks that I talk to, that I'm hearing from, are very appreciative and pleased how, one, it's been adopted, and second, its ease of use.
Thank you.
For those who can remember their password. Commissioner Martinez, and then
Which brings me right to my question related to the passwords, and I'm thankful that in technology you never feel like you've arrived, so thank you for measuring your comments on how happy you were with the system. Going back to Ms. DeAnda's report earlier and how the number of phone calls are related to password resets, when they go in there to that particular screen, and obviously the example given, they give an old email address that's on file, do you have it set up to where it'll also send them a text message to their cell phone? Even if
we do not. We utilize email at this point in time.
But even with email messaging, you can email message, right, a MMS to a cell phone without paying a company to provide text messaging functionality, if you will. I'd really like to ask if, with your permission, Madam Chairman, if that's something they can take a look at and see if that's something that can be implemented without an expense.
We can certainly look at that, yes.
Okay, thank you.
Commissioner Arriaga?
And on the positive side, I go to China twice a year for the National Association of Realtors, and trying to do relationships between the 1.5 million Chinese real estate professionals and the million realtors. And one of the areas that Chinese are fascinated about is the TREC website, which I use a lot because I can have access to it. And they only had licensing for 12 years in China. So they're trying to get where we are now. NAR has been around for 100 years. So they can see how much further they have to go. But when we compare what Chinese have and what Texas have, everybody wants to have a license in Texas. Is it possible? Probably, once they meet all their criteria and take the coursework online. Would they be able to take the exam? That's something that we initially spoke to Mr. Olmexon a year ago, and still trying to work something out in the future. So if you all of a sudden you go from 1 million to 2 million hits, that's because, or from 10 to 20 million, is because the Chinese are looking at it.
Oh. Thank you for that warning.
It is better than the NSA, I might add.
Any other questions for Mr. Watson? Yes.
Can you give us just briefly, if at all possible, clarification on a timeline that we're looking at? Where are we on the continuum of just got started, to rolling it out complete as far as the website construction?
So for the initial website being the appraiser's website, we are at this point looking at content and trying to redevelop much of the content that we currently present. We are also concurrently to that looking at content on the TREC side, but that's for use a little bit further down that path. The implementation of the appraiser website, we're looking at spring, and then TREC probably this summer.
So those are our goals right now for completion and rollout?
Correct.
Okay, thanks.
Thank you. Any other question for Mr. Watson? Thank you. Were you done? Thank you. Ms. Huerta?
Good morning, Melissa Huerta with the Director of Staff and Support Services. And my first report for you is the SS1 report, and it's the budget report as of December 31st of 2013. And you can see on the report that our remaining budget is pretty close to what it should be at this time of the year. So all the expenditures are flowing through the agency and flowing right on time. There's one that I want to point out to you is the SWICAP. It's towards the bottom. It's the statewide cost allocation plan. You will notice that we had budgeted $52,000 for the year. Currently, we've spent $57,000, which is just one quarterly payment. There was the SWICAP that came through this year was a lot more than we had anticipated, and so the total cost for SWICAP this year will be $229,000. But the good news is that the additional amount that is being billed to us is based on our space occupancy here at the Stephen F. Austin building. So we'll be taking that as a credit against the payment that we're going to make. And so, in effect, we don't have another payment. We're actually due a refund from the Texas Facilities Commission for $3,000 that we've overpaid in the rent. And as you can also see, the revenue is coming in according to what we'd had projected. So everything at this time of the year looks really good for our budget. Is there any questions?
Madam Chairman, just one little,
Sure.
I just want to make sure I understood this, the SWICAP you were talking about. So we're over $4,000 there, but we're going to turn around and get it back, which makes us just about even.
Yes,
We're going to
ma'am.
get it back because of the fact that
Right,
we've-
it'll be shown up under the office rent because we won't have any additional office rent payment there. So the two categories will net, yes, ma'am.
Thank you.
When do we expect to get that back?
I contacted them earlier last week, and so they're trying to figure out what the difference was because they're a little confused too as to why our depreciation expense, the expense that was allocated to SWICAP went up so much because they were not anticipating this. So because we get the report from the governor's office and the governor siphons it off to the comptrollers who requires us to make the payment to them. And so the Facilities Commission, though, they did provide the information for the building to the governor's office. So there's a little miscommunication there. But we should be getting it. Either we're going to receive the refund or they'll offset it against next year's payment.
Okay, thank you.
Uh-huh. Anything else? All right, so the next report is the S2 report, and this is the one that Doug referred to earlier. So I'm very sorry about the misinterpretation of the report on the last meeting. When I gave that number, I only included the cash balance is what our balance was, and I didn't combine the two, the market value with the cash. So as you can see on this report now, I have them both combined, so it's easier to look at. So our current balance in the Real Estate Recovery Trust is $1.7 million. So that puts us $700,000 above where we need to be for if we had a reassessment.
That's really good to know.
Yes, and the numbers were on the report the last time. It's just I didn't combine them for you guys, so.
Okay.
Any questions? Okay. The next report, the S3 report, shows the potential payments, and it shows the payments that were made year-to-date for 2014. So as you can see, for 2014, we've made $197,880, which is 8 claims. So which puts us Compared to last year, we had 18 claims total. And you can see on our pie chart over here, or my graph chart, that we're getting up there in the payments.
Madam Chair?
Yes, Commissioner Arriaga.
We already paid $200,000 in 2014 in a month and a half.
Yes, sir.
No, this is a fiscal year, right?
Fiscal year, well,
So back to August.
no, well, actually, we started paying in October, but I mean,
Okay. Okay.
right, and we have 407,000 that are potential payments.
Well,
Commissioner Martinez?
will we be taking an executive session today?
Yes.
I'd like to talk about this in executive session, please.
I'm tossing the question to our attorney.
There-
Just talk loud.
Talk about specific cases for advice of counsel, but if you want to talk about payments and money and budgets, in general, that's not executive session.
Correct.
If you want to talk about
Yes.
why something was paid on a certain case, we can talk about that in executive session.
Yes, thank you for pointing that out. I do want to talk about the appropriate intent of items during executive session, not the inappropriate intent. So, thank you.
Okay, thank you,
Okay.
both of you.
And the last report is the Real Estate Inspection Recovery Fund. And on this fund, we have had no payments this year. We haven't had any payments last year. We do have an $8,000 reserve for payment, and the case is currently on appeal right now. So our balance in that account at the end of December was $623,000, and that includes the $8,000 that's set aside. And we have to refund anything over $600,000, or not refund, but pay to the general revenue, anything over $600,000, and that was paid in January, and that payment was $30,982.
Okay.
Any questions on that report?
Did you get a thank you note?
No.
Any other questions for Ms. Huerta? Thank you.
Thank you.
Thank you to all the staff for your reports. We appreciate all your hard work. And I was actually down here on one of the ICE days, and a whole bunch of the staff was here working. I just thought I'd tell you that just because they had an ICE day, they didn't all stay home. That's interesting. Now, agenda item 6, the report by the Real Estate Inspector Committee, and I believe immediate past Chairman Brad Phillips is going to make that report.
Madam Chair and Commissioners, thank you. The committee's been very busy. The Education Committee met several times since our last commission meeting. Full committee and 2 subcommittees met last Monday. It's been very active on education as well as some other issues regarding licensing and core and continuing education. The committee is recommending a modification to 535-223 that will insert a notice in the preamble. Basically, it's a consumer notification that the inspector may include contractual information that is not necessarily a limitation of the Real Estate Commission, but contractual information between the inspector and the consumer. Additionally, we're asking for emergency rule to clean up a minor formatting area in 535-231, and the committee elected a new chairman, Mr. Brian Murphy, as chair, Mr. Steve Reinhardt as vice chair, and Mr. Michael DeHart as the secretary for the current year. With that, that concludes my report, unless you have questions.
Any questions? Mr. Phillips, thank you for your service as chairman of the committee, and we appreciate you, and we look forward to, I guess, seeing Mr. Murphy from time to time now.
Hopefully.
Thank you.
Thank you.
Report by the Education Standards Advisory Committee, Chairman Susan Jones.
Good morning. Thank you. The Texas Real Estate Commission Education Standards Advisory Committee met on January the 7th for another very productive committee meeting in Austin. The committee began the meeting with a review of the law of contracts and promulgated contracts forms course approval forms and recommends adoption at today's meeting. The committee also reviewed the real estate finance course rules and form and recommends proposal of those at today's meeting as well. We've worked very hard on these rules and course approval forms and feel that they are extremely valuable to all interested parties, including proprietary schools, instructors, and students. The group had a lengthy discussion on issues associated with correspondence courses, including lack of effective regulation of content, delivery, and instructors, and what approval processes are utilized by other jurisdictions of the distinction between a correspondence course and alternative delivery course, such as an online, and whether now that most correspondence courses are delivered online, the distinction is even helpful. We heard from Mr. Olmixon and staff on the history of this issue, and after discussion and consideration of several options, the committee decided to recommend to the Commission that TREC education rules be modified to require all courses accepted by TREC for credit be delivered via classroom or classroom equivalent, which would be like a webinar, live webinar, by an alternative delivery method that includes approval by IDEC or ARELO, or offered for academic credit by a college or university. The committee also recommends that these changes become effective 1 year after approval by the Commission to allow providers of correspondence courses adequate time to develop courses that meet the new requirements. Our committee will discuss and evaluate this proposal further at the April 7th meeting and bring a draft rule which will, among other things, provide more specific definitions of acceptable delivery methods of courses to the Commission at your April meeting at the end of April. We really invite all interested stakeholders to take part in helping us develop these new rules, and we look forward to presenting specific recommendations to you at the end of April. We also began reviewing instructor experience requirements. The committee discussed several ways to improve quality of instructors throughout the state and realized there are many possible ways to address this issue. The committee members agreed to do research on their own to see what other organizations and jurisdictions do to ensure the quality and education of their instructors. We will continue this discussion at our next meeting and report back to you on that as well. I've used the example of our committee by saying it's like buying an old house, and the more you dig in, the more things you find you need to fix. And so this goes on for long periods of time, and any time that we feel that we have not gotten sufficient input from stakeholders, which we did not feel we got on the issue of the correspondence courses, then we are in no rush to fix it until we hear from other people, and so that's what we're doing. So as you've heard, we've been pretty busy, and our next meeting will be April the 7th at 10 a.m., and this concludes my report, and I'm available to answer any questions.
Any questions for Chairman Jones? Thank you and your committee for all your hard work. I'm not sure you knew what you were getting into, but I personally thank you.
Thank you.
Carrie Luce, are you making the report for broker responsibility, or is that, yes? You want to speak? She's going to talk to that about that.
Okay. This is the report from Broker Responsibility Working Group. Mac McClure, who's the newly elected chair of the group, was not able to be here. The group had its first meeting in well over 2 years last month and got right down to work. The meeting began with opening remarks from Administrator Oldmixon on the history of the working group and an overview of the group's charges. The working group will be reviewing current broker responsibility requirements as established by the statute and rules, and then they will review the current broker responsibility continuing education requirements and effectiveness of these requirements. In addition, the group will be working to evaluate the point system for experience on the broker application. The group decided to focus on the current application forms first to address value and fairness concerns in relation to commercial transaction, property management, and other miscellaneous transactions, and the members have formed subcommittees to review these items. The next meeting of the group will be held on April 7th. I'm sorry, it's going to be held on, I think, March 25th. March 25th. And then they'll review the information and possibly come back with a proposal at your April meeting.
Okay. And did you want to talk about the person?
Oh,
tell me.
is it just the one
Yes.
request? Generally, since you'd gotten some requests for comments on agenda items on the report agenda item is for committee chairs to make reports on the meeting itself. If there's someone who wants to talk about a specific issue that is before that committee, then that issue needs to be addressed either under a specific agenda item for that issue, or if there's not an agenda item for that issue, then it could be just brought forward under agenda item 9, general comments from visitors on non-agenda items.
Do you want to confer with the speaker? Mr. Albers, you want to do it next during general comments? Okay. Thank you, Ms. Lewis, and thank the Broker Responsibility Committee for taking on another awesome task. So now we would go to agenda item 9, which is for general comments from visitors on non-agenda items. And I would call on Rick Albers to come and speak since he has turned in a card.
Thank you, Madam Chair and Commissioners. I'm here to speak on agenda item number 9, which was the Education Standards Advisory Committee report. I'm on that committee, so I'm here to support our chairman's report to you.
Okay.
And she has given a very fine report. And so, what I want to clear up a little bit is make it very clear what she was talking about the delivery of courses.
Okay.
What we want to have is to make correspondence courses go away. Just want them gone on MCE and on core. And I'm going to speak to you not as a member of that committee, but as a prior commissioner who used to sit in your chair.
Before you get too deep into it, let me tell you that we have a 3-minute limit on people
Okay.
who speak. So
All right.
you're
And
you're going to begin now,
I will-
since I
will
failed to
abide
tell you
by the
that to start
3-minute
with.
limit.
Okay.
Okay. And give me a little 15-second warning, if you would. I'm going to read you your mission statement. Your mission statement, which is on every TREC advisor, it's all over the website. It says, the agency exists to safeguard the public interest and protect the consumers of real estate services. In accordance with state and federal laws, the agency oversees real estate brokerage, appraisal, inspection, home warranty, and timeshare interest providers. Through education, licensing, and regulation, the agency ensures the availability of qualified and ethical service providers, thereby facilitating economic growth and opportunity in Texas. The problem that we see with the correspondence courses is that they're not delivering the education. It's not protecting the public interest. Your mission is to protect the public interest. It's not to protect the interest of the licensees. It's not to protect the interest of the education providers. It's the public that you're here for. If these licensees are not getting their education, then all that they are, I hate to use this word, they're just salespeople. They're in a different kind of context than a salesperson's license. They are not being agents of their principals. The Texas Real Estate Licensing Act is an agency law, and they're going out and acting like used car salesmen. They're not getting it. If you look, the problem with the correspondence courses is that they're all being, or at least they all seem to be delivered by internet now. They come up, and I have taken them, and if y'all haven't, you should do one. When you go onto the page, what you get is the materials, and usually in the upper right-hand corner, there's a little place to click to go to the next page. When you go to the next page, that icon's still there. You don't have to read down to the bottom. You can just click, 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 click through it as fast as you can. You take a very poorly written test. If you miss a question, it flips you back, and then you can just click again and guess again at the next right answer. I went through a course. I clicked through the pages. I took a screenshot of every page. That was the vast majority of the time that it took me. I answered most of the questions wrong on purpose. It was a TREC 3-hour ethics class, which is one that I'm certified to teach. And I went back again, went back and back, and it took me less than 30 minutes to get through that without ever reading. Again, probably 80% of my time was taking the screenshots. I know of people have come to me saying that they have done this in very little time. If you want to increase the pass rate that y'all were talking about on the broker and salesman exams, you need to get rid of these. The great thing that we have now with the internet is we have other distance learning methods. We've got webinars, virtual classrooms, video conferences that can do the same thing for distance learning and give them a good education.
Thank you.
I implore you to do your duty under your mission statement.
Thank you, Mr. Albers. Are there any other general comments from visitors on non-agenda items? Commissioner Arriaga?
No, if it's over, I'd like to make a comment.
I'm sorry, what?
If public hearings is over, I'd like to make a comment.
You would like to make a comment? What? Okay.
Fascinating. Don't know the gentleman, but I agree 100%. And the reason for that is because in my area, I've always had a feeling that people don't take their own continuing ed. When it's correspondence, someone else does it for them. So I went online, had nothing else to do during those cold days, and figured out and saw different brokers' office and how they're related. And if you could see that, if you look at December 28th, 29th, and 30th, just and see who got all their continuing ed all in one evening, it seems all the same day. But then everybody else in that office, someone else in that office had the same dates. And that question was the same computer, same origination, and I know we cannot check into that, or maybe we can. I believe that there is some concern to be in the future. We need to study this a little bit further.
Okay. Any other general comments on non-agenda items? I'm going to say one. We have a whole bunch of visitors in the room, and I thank you for coming and participating in government in action. And now the commission will prepare to adjourn for executive session to discuss pending litigation or obtain advice of legal counsel pursuant to Texas Government Code 551.071. We will be gone an hour and 15 minutes. On February the 10th, 2014. Thank you. 12:41 sometime. Yeah, 12:44. And we will be moving forward with agenda items 11 through 15. We are going to move the agenda and hear agenda item 13 first. And I am going to appoint TJ Turner as the presiding officer for items 11 through 15.
Thank you, Madam Chair. At this time, we're going to take up agenda item number 13, consideration and possible action regarding proposal for decision in the matter of docket number 329132488, REC, Texas Real Estate Commission versus Tammy Jupe. I'm going to place a, excuse me, 5-minute time limit on presentation to council and presentation of the petitioner. If you want to reserve some time for rebuttal, let me know, and I'll handle that accordingly.
Okay, I'll just introduce the case.
Yes, ma'am.
Carrie Lewis, General Counsel. This case was brought by staff based on 3 consumer complaints received, all involved failure by respondent to remit money to clients in a property management relationship and commingling of client funds with respondent's own. The administrative law judge issued a PFD on December 18th, 2013. No exceptions were filed. The administrative law judge recommends revocation of respondent's license and assessment of a $32,000 administrative penalty.
Mark Moore, and I've got the attorney on the case, Ms. May Cooper. We agree with the proposal for decision and recommend that it be adopted, and Ms. Cooper and I are available for any questions you may have about the decision. Our position on it.
I just want to correct, it's $32,500 that was recommended by the ALJ.
Commissioners, do you have any questions for staff attorneys? I've received notices that Ms. Chupi would like to appear today. You can approach. Thank you.
I just want to let the commissioner know that I have found the files that I've needed. I ran across them when I leased a property from my bookkeeper, and anyway, I found the files and I would like to be able to present them, but I need to get with my attorney to do that. So I'm asking for the hearing to be reheard.
Commissioner Arriaga?
Yes. What would be different in those files that we might have to reconsider?
Well, I didn't have anything to give to the commission because I thought it was lost in a fire, because we had a fire. And what I found, because moving into this new facility, that my bookkeeper had a box that had to do with these three cases exactly. And so, like I said, I thought that they were missing, and they weren't. And so I would like to be able to go over it with my attorney. He's not here, he left earlier, but to be able to have a rehearing because I wasn't able to present anything.
At this point, this is based on the administrative law judge's recommendation, so we're not at a point for a motion for rehearing. I think we'd have to go through the process for a final order, and then at that point, after a final order is issued, if you and your attorney want to bring a motion for rehearing, you could do so under the rules that are set out in the APA for motions for rehearing, that it would have to be new evidence, and you'd make all those claims and grounds that would fall under those requirements. So at this point, any evidentiary hearing is not before this body. That would be for a SOA judge hearing. So this is for them to make a decision on the PFD that was issued and issue a final order on the discipline.
Okay, so we have a chance to come back then.
You always have the ability to file a motion for rehearing after a final order is issued.
Okay, thank you.
Commissioners, are there any?
Our rules have the specific requirements for what a motion for a hearing can and cannot do.
All right, thank you.
Thank you. Anyone else have any questions? Staff, you have anything else to add? Is there a motion regarding possible action on the proposal for decision from SOA?
Commissioner Thomas, may I move that the Commission revoke Ms. Jupi's license and assess the administrative penalty of $32,500 against her.
Second.
I have a motion and a second. All those in favor say aye.
Aye. Aye.
All opposed? At this time, we're going to rewind back to agenda item 11, and we'll recall our general counsel to give us a preview.
Agenda item 11 is consideration and possible action regarding proposal for decision in the matter of the Texas Real Estate Commission versus Myhan and Tonthat. This case was brought for revocation of Ms. Tonthat's license following payment from the real estate trust account of $50,000. The statute allows for revocation in this situation and also allows for probation of revocation. The PFD was issued on September of 2013. Exceptions were filed on October 1st of 2013, and a corrected PFD was issued on October 17th of 2013. All of that material has been provided to you. The ALJ found, under the findings of fact and conclusions of law, that grounds exist for revocation of the license. However, based on what he considered mitigating circumstances, that the revocation should be probated with the requirement that respondent repay the trust account in full within a reasonable time as determined by the commission.
Mr. Moore?
Yes, we partially agree with the proposal for decision and partially disagree. We agree with the probation. We disagree that the probation be probated and that there be a payment plan. We feel that we were following the recent precedent from this body and the Hawk decision and a recent recommendation from the SOA judge, which the commission adopted, where a payment plan was rejected in similar circumstances to this. You do certainly have the authority to do a payment plan, so we're not arguing that. We do think it, in this situation, to protect the public because of the underlying judgment was for a breach of fiduciary duties and fraud. So those are the main reasons why we think a payment plan is not appropriate in this situation. And we're available, and I do have the lawyer on the case, Sharon Harris, as well, to answer any questions that you may have on that.
Can you just one more time, because you're asking us to make a decision that's different, not entirely different, but different from what the ALJ recommended. And as you know, we're going to have, if we do so, then we have to provide a reason why we do so. And can you just tell us what, in your opinion, would justify that action?
Yeah, so and the main reason is the judge. Yeah, and the judge, we thought the SOA judge made a recommendation that he believed in. It wasn't frivolous, so I think he thought hard about the case. He thought it should be a payment plan allowed because Ms. Tonthat represented that she could make a $20,000 payment and could do the rest by payment plan. And he also thought there were mitigating facts in this situation, and that her broker testified, said she was a valued associate, and she needed the money to support her family. So these are not easy decisions for us to look at either. There's revocation is a very serious matter, and we take it very seriously. We do think that the statement of not being able to pay was not supported by any evidence. And in the Hawk decision, that's one of the things that the SOA judge looked at and said there was no tax records, there's nothing that shows they're unable to pay. And in here, we do know we have a pretty large underlying judgment. It's over $220,000. It was 3 years ago, and we have no evidence that even a penny has been paid on that judgment other than the $50,000 that the real estate or that came from the recovery fund. We also know that the recovery fund order was about a year ago, I think it was late February, and there's been nothing paid back on that either. So we are concerned about that.
Thank you. Commissioners, anyone else have any questions?
I have a question before a motion is made. I don't have a problem with getting paid on a term basis. The idea is to get as much money as we can back. The problem I have is the probation. That is not acceptable. But I want to go on record that we can discuss later on that if people want to pay off their what they owe, they can, but really nothing can be done or no action taken until everything's been paid off. So I want the commission to take that into consideration. Thank you.
Yes, and Ms. Tonthat is present and we've been informed, would like to speak as well. Oh, sorry.
Ms. Tonthat.
Hi, Commissioners. I just want to make sure that you understand that I did not commit fraud. The summary judgment is due to the lawyer that's supposed to representing me that did not answer the admissions. So that's the summary judgment that I got, and I'm willing to pay back the recovery funds. I understand that because it had been pay out, but I am not able to pay at one time $50,000. I was able to pay $20,000 at one time and soon, and then the installment. But I would ask to have my license to be continued to be able to work in order to pay back the funds and the debt that I borrow. So and then also, I want you to know that I had been have my license for more than 23 years. I have no prior record to it, and this is the only job that I'm doing full time. And if I don't have my license to be able to work, I have no way to pay back.
Is it appropriate for us to ask questions?
Absolutely, I think so.
Just out of curiosity, since this originally took place, you've been continuing to conduct real estate transactions. Do you have an idea how many transactions you've conducted since this started?
I have probably 20, 30. I can't remember, but I continue to work.
Okay, thank you.
Ms. Tonsat, I just want to make sure I understand you correctly. Did you say that the judgment that was entered against you was as a result of a summary judgment?
Yes, and I do have the affidavit from the attorney supposed to representing me that he did not file the answer.
So I just want to make sure again that I'm getting this straight. You were sued. You had an attorney representing you.
Yes.
The plaintiff filed a motion for summary judgment, and your attorney failed to respond to that motion for summary judgment, and judgment was entered against you.
Yeah. When I first got the complaint, I hired an attorney, and he just did not answer. And in his affidavit, he said that he's supposed to file, but his secretary just filed it in the file instead of filing at the court. And that's the result of the judgment, because it didn't answer. It's deemed admitted because they didn't answer the admission.
And did you appear at all? Was there a hearing on that summary judgment motion in front of the judge?
I never got a chance to go to court for that. I never have a day in court.
Did you appeal that judgment against you, or file anything in the court to seek to have that judgment overturned based on?
At first, I could not afford to pay the attorney anymore, so I filed bankruptcy, Chapter 13 bankruptcy in 2007. And then I have to make the payment in that plan, but 2008, the business is very slow, and I could not make the payment, so I failed to complete the Chapter 13. And then on, I just don't know what else to do. And it's just a result of that they claiming from the recovery funds, which I did not know until I got the letter. And I didn't know what to do. I just was waiting to see if the commission sent me any notice that the funds had been paid, or what to do.
So wait, in the findings of fact, says that the commission sent you notice of the recovery fund action in August of 2012. We didn't hear back from you until I'm not sure when. Can you explain why there was such a delay there?
Well, the commission only sent me a letter, and then they didn't, I just wait for.
Is your attorney here today?
No, I don't have an attorney.
Can I see that affidavit that you brought with you, please, ma'am?
Counselor. She was not aware that he's here. He walked in. He walked in later.
Is that her lawyer?
I think so.
I'm James I. Wiedemer. I'm an attorney, board certified as a specialist in commercial residential real estate law. I have worked on Mihan's case some time back. Since then, Sharon Harris took it over and did the other part. But maybe if I could clarify for the commission just a few points. What happened on the summary judgment is there are requests for admissions in the discovery process of the lawsuit that were sent to Mihon. And as you may know, requests for admissions, you just simply have statements, you breached your fiduciary duty and so forth, admit or deny, admit or deny. If you don't respond timely to those, then they're taken as admitted and deemed true. So there never really was a hearing in court on the actual fraud or so forth. It was just simply a mistaken situation. I think if she'd gotten a fair chance to really present the evidence and really go through a formal trial, she would have done much, much, much better. Also, she filed a bankruptcy. At the bankruptcy, I have to admit, I was a little infuriated looking at the old pleadings, and they said, oh, this won't affect her license if you go ahead. What happened is she tried to erase this judgment so it wouldn't have to be played.
Sorry, did you file, did you provide us with a slip letting us know you were going to speak on this agenda item?
No, but I am an attorney, and she may need a little representation here. I have worked on this case before with her. I've actually appeared before the commission once before.
Commissioner?
I understand that. Yeah,
Sorry, I have kind of a basic question. Are you here representing someone else this afternoon?
No, was here on the education issues.
Okay.
Are you representing her right now? Because if you're not representing her,
just for this hearing, yes, because I don't want to see this happen. I mean, this is very important because it's her licenses at stake, and I would normally not just dive in, but
were you representing her when her requests for admissions were unanswered?
No. I just did a very brief appearance before the commission. I don't know if anybody remembers that. It was back in 2012 in the fall. Yes, as I said, my name was James Wiedemer.
Commissioner,
anybody have any questions for Mr. Wiedemer?
I feel extremely uncomfortable that pardon me, that Ms. Tontat has stated that she has no representation here, and then certainly Mr. Wiedemer.
I just saw her case come up, and I was familiar with it, so I thought maybe I could straighten a few points out for the commission.
Are you doing this pro bono?
This is pro bono for now.
Okay. Well, you have a great memory for an attorney that was not involved at this present juncture. My commendation to you for having such a good memory.
We appreciate your input very much. Thank you for addressing the commission on her behalf.
Yes.
I'm afraid we do also have procedures by which we're notified who's going to be speaking and we also have time limits on presentations that we have to abide by to get to the rest of our agenda.
Okay.
So
Well,
thank you for your time.
I was trying to be very, very brief. I understand the commission needs to move, particularly today.
I appreciate that. I'm reviewing this affidavit right now. If there are no other questions, and I'm sorry I didn't catch your name one more time.
I'm James Wiedemer, and as I said, the bankruptcy, she attempted to discharge it, but because the original judgment was based on fraud, the bankruptcy judge said, I can't discharge the judgment. At that time, the plaintiff's attorney said, oh, we're only interested in recovering against the commission, and it won't hurt her license, which did come up in the bankruptcy thing, and I'm like, that really was basically a false statement because it is hurting her license.
Unfortunately, we have a very limited jurisdiction today on what we can do with this administrative law judge's decision, as I understand it. Thank you for your time today. We appreciate it. I think that there are other opportunities afforded to Ms. Tontat to challenge what may or may not happen today and what has happened at SOA that she can afford herself of. That this is not the opportunity or the place or the time to relitigate the underlying case. We're here to decide whether or not we're here to decide, pardon me.
It can't be relitigated at this point.
I meant pardon me, please stop interrupting me. We're not here to relitigate the underlying case. We're here to decide whether or not we think the ALJ made a decision that we can accept as an administrative body. So that's what we're here to do. I appreciate your time. Thank you very much. I'd like to review the affidavit now. If the commissioners have any more questions for Ms. Tontat.
May the record reflect counsel has been asked to step down.
That's fine. The record can reflect that.
Thank you.
We've reached the time limit anyway.
Commissioner, while you're reviewing the affidavit, might I ask, is there someone else here to speak on the other side of the case?
Mr. Moore, do you have anything else you'd like to?
I would like to respond.
Please. We'll give you a couple minutes.
Yes, and that's one of the main reasons we don't relitigate a case is we don't have the other side here. So even if we have an affidavit where an attorney says they made a mistake, my understanding is when you make a mistake and there's money involved, you pay something. So if I come forward and say, I made a mistake, that car accident was my fault, and I pay $0, you might call into question my apology or what the lawyer is saying in that statement. But the main thing is we don't look behind the underlying judgment because we really can't. We know we have a fraud judgment. The other thing I wanted to address, Mr. Turner, or Commissioner Turner, was the notice was in August 23rd of 2012, where Ms. Tontat was notified, and so that's been about a year and a half with no payments of any kind, either on the 2009 judgment or on the 2012 order. And if you have any other questions. Yeah, thank you.
I do not. I will take this time to inform my fellow commissioners that there are affidavits from 2 attorneys here that they're copies of affidavits but appear to be notarized, and both affidavits state within the document that each of these attorneys were representing Ms. Tontat were charged with responding to discovery requests and failed to do so, and they're averring that within these affidavits.
Mr. Chairman?
If there are
In reading
comment
over your shoulder, why does it say unofficial?
I don't know. I don't know where these are from. I see a notary signature and a stamp. I see that these were filed as a matter of record at some point in Fort Bend County District Court. Probably what it means is it's an unofficial copy, so it's not a certified copy from the district clerk. That would be my guess. But not that the document. It's not some proclamation that the document is unofficial in terms of its content. That's not the way I understand it.
Commissioner Turner, Carrie Lewis, General Counsel. So there's no confusion, I want to direct the Commission's attention to page 6 of the PFD where the findings of fact 4 and 5 are. There's been some talk about dates, and I just want to make sure that the Commission members are focused on the findings of fact by the ALJ, and that is number 4, and this is page 48 of 429 if you're looking for it. On August 23rd, 2012, that's the date that Commission staff notified respondent that an application for an order directing payment out of the trust account was filed, and the letter stated that respondent was entitled to file a response to the application if she wished to contest the payment, and the ALJ found after reviewing the evidence before her that the respondent did not respond to that notice. The second date, which I believe both parties have referred to, is February 27th, when the order was, and that's it's actually a second 4, paragraph 4. That's when the order directing payment of $50,000 from the trust fund was issued. And then on July 15th of 2013, that's when enforcement staff issued a notice of a lead violation to the respondent, notifying them that payment had been made and was due. So just clarifying the sequence of those dates and letters.
Thank you. Are there any more questions? Any commissioners?
If there's no more questions, I have a motion.
Yes.
And first, I'd like to state to the council that attempted to assist, we appreciate you being involved and trying to assist a public citizen. Since you're not under retainer by her, as we were all educated earlier today, our job is to protect the public, and we take that very seriously. So, in this particular matter, I'm going to move that the Commission strikes the conclusion of law number 7, and the specific reason and legal basis for deleting this conclusion of law, that the ALJ's opinion that the respondent, quote, the respondent's license be revoked with the requirement that she repay the trust account in full within a reasonable time as determined by the Commission, is a recommendation as set out in Section 3 of the corrected PFD, and not a conclusion of law. Commission Rule 533.7 specifically provides that, quote, the Commission shall render the final decision in a contested case and is responsible for imposing disciplinary action and or administrative penalties against respondents who are found to have violated any of the Commission's laws or rules. The Commission welcomes recommendations of administrative law judges as to the sanctions to be imposed, but the Commission is not required to give presumptively binding effect to the judge's recommendations and is not bound by such recommendations. Second part of this motion is that all proposed findings of fact and conclusions of law, as amended or adopted, be submitted by any party that are not specifically adopted in this final order that's denied. So I have that, and I'll submit this motion in writing for the record, so that way we have it. And there is a third part to this motion. Again, you know, we take these cases very seriously, and I'm sorry there's three parts to this motion, but thank you for the indulgence. Further, I will move that the Texas real estate broker license of Ms. Tontant is revoked effective at 5 p.m. March the 5th of 2014, and we choose not to follow the recommendation of the ALJ to probate the revocation because of the seriousness of the respondent's actions in this underlying case. The Commission's mission to protect the public and to be consistent with prior administrative decisions of the Commission as more fully set out in the exemptions.
Second. I have a motion and a second. All those in favor of the motion, say aye.
Aye. Aye.
All opposed? Nay. Moving on to agenda item, pardon me, 12. That is consideration and possible action regarding proposal for decision in the matter of the Texas Real Estate Commission versus Britt Massey. I understand that Commissioner Arriaga will be recusing himself from consideration of this agenda item, and I'll recognize his recusal.
Carrie Lewis, General Counsel again, and can I just confirm, Commissioner Turner, was your vote a nay on the last one?
That's correct.
Okay, that's what I thought. Okay, agenda item 12, consideration possible action regarding proposal for decision in the matter of Texas Real Estate Commission versus Britt Joseph Massey. This case was brought by staff requesting revocation of Mr. Massey's license based on several underlying consumer complaints of negligence, fraud, and failure to remit funds, and on staff-initiated administrative complaints of failing to report a felony, procuring a license by fraud or misrepresentation, and failing to repay the commission following payment out of the Real Estate Recovery Trust account. A PFD was issued on November 7th of 2013. No exceptions were filed. The ALJ recommended revocation and assessment of a $15,000 administrative penalty. The administrative penalty was based on making a false statement on his license application and failing to notify the commission of guilty pleas within 30 days after the two felonies.
Mr. Moore.
We agree with the recommendation and would like to be adopted. I do have the lawyer here on the case, Ms. Cooper, as well, if you have any questions on the case in addition to what Ms. Lewis spoke about.
Any questions?
And Mr. Massey is here. I wasn't sure if he wanted to speak or not, but he is here. No? Okay.
We don't have a card for Mr. Massey. Is Mr. Massey here? Would you like the opportunity to speak? Yes, sir. I'll give you 3 minutes.
Thank you for your time. I think this case has been going on for about 4 or 5 years. I'll do my best to try to sum it up in 3 minutes. I've asked the commissions and other people who are knowledgeable in real estate. I was sued, and me and a title company was sued, and I was found to be 20% liable. And based on that 20% liable, the judge went ahead and made the commission pay $100,000. I haven't really been made to understood why if somebody is made 20% liable, why he has to pay the whole $100,000. And the second part of it is the case is on appeal. So the case was was appealed immediately after the verdict, which was about 2 years ago, and the commission went ahead and paid the $100,000. And it was brought to my attention, if it gets reversed, I wanted to know what happens to that $100,000 that was paid to the plaintiff. I was told that a writ would be put on him, which I think I understand what a writ is, and it would be good because this gentleman does have 63 shopping centers and he owns over 400 trucks for logistics, but all those companies are in Mexico. So those writ that you would put on him, you would probably never see a dime of it. Only other thing I can say is I've been licensed for 20 years and I've never been in trouble with the Real Estate Commission or anything like that. I have about 40 to 60 agents under me, and I own 2 real estate offices, one in McAllen and one at South Padre Island.
Thank you. Anybody have any questions for Mr. Massey?
Sorry.
I have a question. You're the broker for
No,
2 companies?
I was only the owner. I wasn't the broker.
Okay.
Commissioner Martinez?
The other individual, are they a U.S. citizen?
No.
Okay.
And the total judgment in that case was far in excess of $100,000, right?
I believe it was around $4 million.
Any other questions?
There was the root of a question that was asked. Do we want counsel to respond as to kind of what the procedures are if we do go after the 100K?
Would you like to respond to the question about the effective appeal on the payment from the recovery fund and action today?
Right. When this came before the recovery fund, a notice was sent out, just as in the last case, and no documentary evidence that an appeal had been found was given to the commission, nor did the Attorney General's office find that an appeal had been found on this case. So if in fact an appeal has been filed and it is overturned, then I suppose we would address that at that time. It hasn't happened to my knowledge before. So, you know, that would be an issue, but I don't know if to the ALJ who heard the evidence, I don't know if this issue of appeal was brought before the ALJ also. And if it was, she weighed that evidence, but that would be new evidence.
Mr. Moore, do you have any idea whether or not evidence of the appeal was presented to the ALJ? State your name for the record, please, ma'am. I know you were introduced earlier.
May Cooper, staff attorney for Standards and Enforcement. Mr. Massey did raise the issue of an appeal. He never presented any evidence that an appeal had been filed.
Okay.
So.
Briefly.
I strongly disagree with that. When I went to the Soho judge, I brought that document with the showing the appeal.
Ms. Lewis, should that prevent us from taking any action today?
This ALJ found other grounds. She didn't find on the underlying case, but she did find other grounds. If you look at the proposal for decision, the conclusions of law number 5 says Mr. Massey is subject to disciplinary action for making a false statement on a license application to the commission, pleading guilty to 2 felonies, and failing to notify the commission of the guilty pleas within 30 days of their entry, and then held that the license is subject to revocation and assessed the recommended assessing penalties of $15,000. So under the conclusions of law, the basis for the disciplinary action is not tied solely to the recovery fund payment.
Thank you. Any other questions, commissioners?
Mr. Chairman?
Yes.
I'm ready to make a motion if there aren't any other questions.
Please.
I move that the commission revoke the salesperson license of Britt Joseph Massey, effective 5 p.m. March 5th of 2014, and assess an administrative penalty of $15,000.
I have a motion. Do I have a second?
Second.
I have a motion and a second. All those in favor, say aye.
Aye.
Opposed? All right, moving on to agenda item 14, consideration and possible action regarding a motion for rehearing in the matter of Texas Real Estate Commission versus Jessica Martinez. We're going to go in a slightly different order once Ms. Lewis introduces this for us. Thank you.
This is a motion for rehearing, as you said, in the matter of Texas Real Estate Commission versus Jessica Martinez. The rehearing request comes on the final order that was issued by this body on October 23rd of 2013, and the motion was timely filed, replies were timely filed, and the date for the motion, to hear the motion for rehearing, was set as this date at this meeting.
Thank you. Mr. Pluthner, we're going to let you speak first since it's your motion. I'm going to give you 3 minutes. Same for our staff to have an opportunity to respond if they want to. We'll see if there's need for rebuttal or not, okay?
All right, thank you. Good afternoon, Commission. As indicated, my name is John Pluthner, and I'm joined here today, and I represent Jessica Martinez, and she is joined by her fiance, Deputy Sheriff in Bexar County, Chris Estrada, as well as the broker for Ms. Martinez, Brian Tyndall. We're here today on a motion for rehearing regarding the punishment of revocation, which I am going to say is a death penalty. And it's a death penalty simply because 2 reference letters that were unable to be procured in a form that the Commission found acceptable. I don't want to go into all the details of it, but in our research, what we have found is that the death penalty or revocation has been imposed almost exclusively in situations that harm a consumer or involve an administrative failure on the part of the licensee and perhaps a failure to appear or some combination of that. And I can assure you that in this case, there's been no harm to a consumer. Ms. Martinez has been at every hearing, and she's not done anything in a sense that would be an administrative failure, in my opinion. We do go back to those 2 letters, obviously, and one was a failure to redraft it and sign it by another deputy sheriff in Bexar County, and the other letter was one that a lady who was a recommendation supposedly for Ms. Martinez changed her mind. Now, keep in mind, she's on probation. She had disclosed situations in her life that led up to her application, and that she was put on probation. She had promised and was required to provide letters of recommendation. She had 3 individuals named, and she's put on probation. One of those individuals changes her mind. And all of this occurred after she had her license and she was on probation. None of it occurred after she was on probation. And I'd like to read just a sentence from the response filed by the Real Estate Commission attorneys, and I'm quoting from page 5 of their reply. A probationary period is a testing period during which a licensee is placed under close supervision. During this, quote, testing period, unquote, a licensee is given the opportunity to demonstrate to the Commission that he or she is fit for licensure. There is nothing that relates to an act or non-action on her part that comes after being placed on probation. It all relates to this one person changing her mind and another person signing a letter and not formally and completely redrafting the letter. And it's our opinion, it's our request that you grant this rehearing so that we can be given an opportunity to seek a situation where it's not the death penalty, it's not a revocation of her license. Thank you. And I'll be here if y'all have any questions.
Impeccable sense of timing. I'll give you that. Any questions for Mr. Pluthner? Okay.
May Cooper, staff attorney. I just want to address a couple of things. Ms. Martinez's honesty, trustworthiness, and integrity was in question when she filed her original application. She had a criminal charge, and she also submitted letters that she wrote on her own behalf. And the ALJ gave her the benefit that those people gave her permission to write those letters on their behalf. And so did the commissioners when you issued that probationary license. And part of the terms of her probation to keep her license was to basically prove that we all rightly gave her that benefit of the doubt by submitting 2 letters, one from Mr. Miller, one from Ms. Burris. And both of those letters were required to be written by those people and notarized. And she did, excuse me, and she was not able to do that. So she violated not just 1 term, but 2 terms of her probation from the get-go. So we had a hearing. She was able to present evidence at that time, but whether or not revocation was appropriate, the ALJ disagreed and recommended that we revoke her license. And based on this, we ask that the motion be denied. If you have any questions.
Any questions for Ms. Cooper?
Not at this moment.
Mr. Plithner? I'll hold you to it.
I think the record would reflect, and I can get it quoted for you if you need to, but leading up to the hearing that basically granted her the probation, all those individuals were contacted by the Real Estate Commission. And it's not just some representation on Ms. Martinez's part that was relied upon without verification. Those individuals were contacted and talked to by attorneys or staff of the commission. So going into the probationary hearing, it wasn't just Ms. Martinez saying something. So, thank you.
Thank you for your time. Any questions from any of the commissioners? Does anyone have a motion at this time?
The motion's already here.
Oh, I'm sorry. We have a motion presented to us. The motion is for rehearing.
I do have a question for the
Yes, sir.
for the council. So I heard your statement. I didn't hear new evidence. What kind of new evidence if you get a retrial? What I mean.
Well, if we were to go, if the rehearing were granted, what we would seek is a different punishment, a lesser punishment. And that would be, we're not contesting what the facts are. The facts were pretty well laid out. So if you're talking in terms of evidence, what we would present just simply is the appropriate nature of a punishment for Ms. Martinez. And we agree that some punishment is due. We're not walking away from that issue. So not so much new evidence, but just simply looking at her circumstances and what she did. She didn't harm any consumer. There's no administrative failure as I deem administrative failures. She's been showing up here. Her broker's been coming here. And let's face one thing too. Her fiance is here too at my request. He's a deputy sheriff in Bexar County. I mean, this is a responsible person. And I'm not going to get into any more of her personal life, but she's been working as a real estate agent all this time, and her broker stands behind her. Her fiance stands behind her. And it may be a multiple chance. I think it may be looked at by the Real Estate Commission as she's had her chance, but I think it's appropriate in this case that the death penalty not be invoked on her, that something lesser, whether it's probation for a number of years, fine and a probation. That's where I think is where I would like to argue on a rehearing.
Okay, thank you.
Okay.
Any more questions?
I'd like to respond.
Please.
Just briefly. Respondent made all these arguments at the last hearing we had. He did argue for alternate outcomes other than revocation, so he hasn't presented any new evidence at this time. So based on that, I don't think that granting that motion would be appropriate. Thank you.
Thank you. All right, at this time, again, we have a motion on the floor. This is a motion for rehearing of action previously taken by this commission. So if you want to grant the motion for rehearing, you'll respond by saying aye. If you want to deny the motion, you'll respond by saying nay. All those in favor of granting the motion, say aye. All those in favor of denying the motion, say nay.
Nay.
Nay. At this time, I will return the floor to Chairperson, Ms. Wukash. Thank you.
Thank you, Commissioner Turner, for handling all of that legal intricacy, and thank you, Mr. Plutner and Ms. Martinez for coming back yet again, and everyone else. So we will move to agenda item 16, discussion and possible action to authorize settlement of recovery fund claims or to take other action on the following cases. Ms. Lewis.
Okay, the first agenda item regarding recovery fund claims is Recovery Fund Case 14-001, DeFever versus Campbell.
Commissioner Hensley?
I'd like to make a recommendation that we authorize settlement on the best possible terms for RF number 14001.
Have a motion. Do I have a second?
Second.
All in favor say aye.
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 And opposed, nay. Motion carries. Ms. Lewis?
The next claim up is Recovery Fund number 14-003, Cleveland versus Powell.
Commissioner Arriaga?
Yes, Madam Chair. Regarding claim number 14-003, I move that we authorize staff to settle the best possible terms.
Have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, nay. Motion carries. Agenda item 16C, Ms. Lewis.
And the last claim before you today is number 14-005, Garrido versus Parrish.
Mr. Jones, are you capable?
Thanks, Madam Chairman. Recommendation that the commission authorizes the staff to a payment of actual damages of $3,515 plus interest, court costs, and reasonable court fees, or reasonable attorney fees. I'm sorry.
Have a motion. To have a second?
Second.
All in favor say aye.
Aye.
Opposed, nay. Motion carries. Agenda item 17.
Discussion and possible action to adopt amendments to 22 TAC, subchapter F, sections 535.62, acceptable courses of study, and 535.64, obtaining approval to offer a course. These amendments were proposed and published in the Texas Register on December 6, 2013. The amendments add a law of contracts and promulgated contracts forms as new subsection E, listing them as 30-hour courses with specific topics, subtopics, and units, and mandated time periods in which instructors must teach each topic. And then in section 535.64, it cleans up the language that's repeated and puts it all in one section regarding where the documents can be found, and lists new forms to be adopted by reference for use by approval for the new law of contract and promulgated contract forms. One comment was received on this proposed adoption, and it's in your materials. And the commenter basically said that there was a lack of ability to adapt to Texas regions. There was not enough time allotted for case studies, and that the areas of property condition disclosure, inspections, repairs, financing issues, and parties to the contract were not adequately covered. Staff respectfully disagrees with the commenter. The amendments were recommended after many hours of thoughtful deliberation by the Education Standards Advisory Committee. And more specifically, they felt that there was approximately 30% of total course time allocated to practice and case studies. And instructors are permitted to include additional practice time or case studies if they feel that's the effective way to teach that particular subject matter. Likewise, time allocated within each unit are suggested times, and an instructor can tailor the time to address specific regional concerns. For example, in a rural area, the instructor might spend more time on the farm and ranch contract as opposed to a condominium contract. Finally, the Education Standards Advisory Committee believes that adequate time for all the courses was allocated to the topics that were felt lacking by the commenter. The committee has recommended or will be recommending changes to all of the core courses required, and they often balance the amount of time in one course versus the entire time that will be spent on a full course. Again, for example, in the Law of Contracts courses, 240 minutes, topic minutes, are allocated to financing. However, there is a 1,500-minute course dealing entirely with real estate financing that applicants must take, and in fact, that course will be before you today as a proposal.
Thank you, Ms. Lewis. We have one speaker who has asked to speak. Mr. Wiedemer, are you going to say something other than the 8 pages that you've already given us? And are you representing TREC or yourself?
I'm representing myself.
Okay, because your thing seemed to indicate that you're representing an organization.
I'm sorry.
Okay.
I should not have created that misimpression.
Okay.
But I'll be very, very, very brief. But Ms. Susan Jones is, and I highly respect ESOC, and they certainly do work hard on these forms. I think my concern was simply, I think that Ms. Jones answered a lot of my questions, that there's a lot more flexibility built into the course in terms of all this substructure with all these detailed minutes doesn't have to be followed. I hope that is made clear, though, to course writers everywhere, and I hope that somehow comes out clearly to the people who are responsible for these courses. I think the only comment I'll reserve, that I think most of my issues have been answered, but I think the only one I'll reserve is I'm a little bit concerned that we don't have quite enough material on these very tough issues that sometimes come up in contracts. In other words, how do you coordinate inspections with repairs, with the option period? And something like that doesn't seem to be specifically dealt where you have a mixture of several different areas, and that's a key question. There's no mention of the amendment to contract form anywhere and how to use it in these situations. Or I just want to make sure agents know what they're going to do. What happens when the property doesn't appraise? What happens if there's problems with the inspections? What happens with these others? I will continue to work with the committee directly and with Ms. Jones, and I hope these changes are made at some future point. Also, one last comment, and I think this is really going to be applicable to your next course, the finance. Updating these courses is going to be a problem, and somehow we need to have a faster and easier system to permit updates for these courses. But that's all I have to say for now.
Thank you, Mr. Wiedemer. You did that in halftime. I appreciate it. Do I have a motion?
Madam Chairman, I move that staff is authorized on behalf of the Commission to submit for adoption amendments to 535.62 acceptable courses of study and 535.64 obtaining approval to offer a course and forms adopted by reference without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
Opposed, nay. Motion carries. Agenda item 18.
Carrie Lewis, General Counsel. Discussion and possible action to adopt amendments to 22 TAC 535.51 general requirements for a license. The proposed amendments were published in the November 15, 2013 issue of the Texas Register, and the amendment simply corrects the time frame that an applicant can submit fingerprints from 6 months to 12 months to be consistent with the time frame an applicant has to take an examination. And no comments were received, and staff recommends adoption
And I have
as
no
published.
one wishing to speak, so I seek a motion. Commissioner Jones?
Let me turn it on. I recommend that staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC 535.51 general requirements for a license without changes to the text as previously published in the Texas Registry, except for any technical or non-substantive changes required for adoption.
Did I hear you correctly, Commissioner Jones? You said move, not recommend, right?
Moved, I'm sorry.
Okay.
I'm
And do I hear a second?
Second.
All in favor say aye.
Aye.
Any opposed, no. Motion carries. Agenda item 19.
Okay, agenda item 19 is discussion and possible action to adopt amendments to 22 TAC Chapter 537, and we have several documents. These are associated. The rule adopts by reference several forms and amendments to be used by real estate licensees. And Madam Chair, before I get into the full summary, do you want to break them into the different groupings, maybe the contracts as one, and then the different addendums we'll handle separately?
That will be fine.
Okay. So we will be looking at agenda items A through F first, and those are the contracts that were proposed. There were many comments received that the Broker Law Committee went through, and all of that material, all of those comments were discussed in your material. I won't read the 4 or 5 pages. Basically, the Broker Law Committee agreed with several of the comments and made several recommended changes to what was proposed, none of which I feel are substantive, so if the commission wanted to, they could adopt these today. Basically, the differences were in Form 911, the minor changes were made to a paragraph so that it was clear that if a property was subject to a lease, that any security deposit would transfer at closing. And then a typo was corrected in a couple of the forms on paragraph 5, earnest money, to insert a blank between within and days. In Form 911 and Forms 2012, 2015, and 30-11, clarification language was put in where leases were to be delivered within 7 days of the effective date. If there were leases on the property, it was clarified that that was copies of leases. And then in all of the contract forms, the paragraph relating to a title policy, shortages, and area exception was revised to be an opt-in provision, whereas previously it was proposed as opt-out, and the fact of whether the printed exception would be amended or not was also left to be a negotiable item between the parties. Finally, let's see. Oh, in paragraph 14, in the contract forms dealing with casualty loss, the phrase that had been inserted, which read, let's see where it is, regarding or cause to restore, that language is thought to be confusing, so that was taken out. And then in the termination option paragraph, the proposed change was reduced from saying that the seller or listing broker must receive to simply changing the day from what exists today from 2 days to 3 days, the time period. And those were all the changes made to what was proposed that the Broker Law Committee is bringing forward today.
Okay, thank you. You want to talk about the addenda now?
You want to do the motion separately?
We could.
Do you want to talk about all of them?
Actually, we have a motion that we're going to take action on.
Okay.
That will encompass it all.
Okay. All right. So now if we look at the addendum, the third-party financing addendum for credit approval, that was revised to add a parenthetical so that it was clear that it was not for use with reverse mortgage financing. And I will say that the committee is going to be looking at the reverse mortgage financing issue more thoroughly at their next meeting in April. And then the other addendum, the other addendums were not changed from how they were proposed at your October meeting, and those addendums were the the mutual termination addendum, and the addendum for property in a propane gas system service area, and the addendum dealing with subdivision information, including resale certificate for property subject to a mandatory membership in a property owners association.
Okay. You wound down?
Yep, I'm done.
Commissioner Justice?
Madam Chairman, I have a motion. I'm going to take deep breath first. I move that staff is authorized on behalf of this commission to submit for adoption amendments to 537.44 Standard Contract Form, TREC number 37-4, subdivision information, including resale certificate for property subject to mandatory membership in a property owners association, 537.47 Standard Contract Form, TREC number 40-4, third-party financing addendum for credit approval, and a new Form 537.54, Standard Contract Form TREC number 47-0, Addendum for Property in a Propane Gas System Service Area, as previously published in the Texas Register, with non-substantive changes made to the forms adopted by references presented by staff, along with any technical or non-substantive changes required for adoption.
A motion, do I have a second? Second. So everyone understands what the motion is to move forward, the propane addendum, the third-party addendum, and the subdivision information addendum, and we vote on that, then we will give you some oral instruction for you to take to the broker lawyer committee if that works for you, Ms. Lewis. Okay, all in favor?
Aye.
Opposed? Motion carries. There's a couple of changes that we feel have come forward that we would like the broker lawyer committee to look at that may appear non-substantive, but we wanted to have the opportunity for that committee to review them. The item on leases, which we applaud that item, which was put into the property condition paragraph, seems out of place in a property condition arena, and seems more appropriate perhaps, and it's for them to decide, but perhaps in paragraph 10. And we'd like to see them consider moving that in an effort to keep things similar in the paragraph to that language. We'd also like for them to look again, if they would please, and make sure that they are comfortable with what is looked at as 7G, the repairs and treatments to be provided by people who are licensed or commercially engaged in the business. And we just want to be sure that the opportunity for a consumer, seller, and buyer to find someone who needs to cut a tree limb off the side of the house or caulk a bathtub, not have to struggle through the yellow pages to find a caulker. In other words, that it allows for a handyman who's commercially engaged in handyman business to do the work that might show up on an inspection report that's not a HVAC or an electrician or a plumber or some other trade that we're familiar with. We just want to be sure that latitude is made available to the seller and the buyer to have someone to do that kind of work. And I believe at this moment, those were those are the major concerns that I'd heard iterated lately. So, Commissioner Justice, did I reflect that appropriately? Okay.
And then the mutual termination, you'd like them to reconsider that as well, because that was
yeah,
not...
yes. There's a lot of dialogue about that one, and we'd like them to look at that one again. I believe they know what the concerns are because they've received a lot of comments about having a possibility of a third choice, which might be to hold the earnest money, to fight about the earnest money, but take away. We're not going to fight about it. A choice for the consumer, buyer and seller, to say we're peaceful about everything else, and we're not going to sue each other about everything else, but we are going to fight about the earnest money. But you can put your house back on the market. I just don't believe you're entitled to it. Give them the opportunity to go that direction, because that's not a choice here.
Madam Chairman, I just want to make a comment, if I may. Everybody up here and anybody who took the time to read all that came forward from broker lawyer knows how much work went into all that. And I think we need to applaud that, and we also need to applaud the number of individuals who took the time to make comments and try to read between the lines and think about how all this comes down to the consumer who we're trying to take care of. So all the input we get, the better things can be, and I hope you'll take it back to them in that spirit from everyone.
That's a very good comment, Commissioner Justice. Thank you. So we'd like to see agenda item 20.
Agenda item 20. And just to clarify on that last item, those forms and rules that weren't adopted are just, you're taking no action on this time, and they could be brought, the proposal is still open, they can be brought back to the commission. Okay?
That was the idea.
Okay. Agenda item 20, discussion and possible action to propose emergency amendments to 22 TAC 535.231, standards of practice, minimum inspection requirements for plumbing system. After adoption of this rule, it was discovered that parts of subsection A were misnumbered, and the error in numbering actually affects the interpretation of the section, inadvertently requiring action that is not actually required under the SOPs, resulting in a misunderstanding. Therefore, staff recommends that we adopt these amendments as an emergency
rule so that this can be corrected for the inspectors and the public.
Commissioner Hensley?
Madam Chair, I move that the staff is authorized on behalf of this commission to submit for adoption on an emergency basis amendments to 22 TAC 535.231 Standards of Practice, minimum inspection requirements for plumbing systems as submitted by staff, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Have a motion, have a second?
Second.
All in favor, say aye. Opposed, no. Motion carries. Item 21. I have two speakers.
Item 21, discussion and possible action to propose amendments to 22 TAC 535.212, education and experience requirements for a license. This, as you will recall, this new rule was adopted by amendments to this rule were adopted by the Commission in their October meeting with instructions for the Inspector Committee to go back and look at some of the issues surrounding the 40-hour fieldwork requirement. They did do that. The Education Subcommittee had several meetings, the full committee had several meetings, and the proposed amendment that they bring before you today creates two options for obtaining substitute experience on an ongoing basis that emphasizes the importance of hands-on training, and then it also keeps the third option in the rules that was in effect prior to the new rule taking effect and prior to the statutory requirement limiting it to 40 hours of field work. They do allow that third option to stay into effect for basically 1 year, to allow providers time to develop courses that comply with the first two options that they want to see going forward in this rule. And staff would recommend proposing the amendments as presented.
Thank you. Ms. Lewis, I have two speakers on this. Each speaker will be limited to 3 minutes, and we would very much appreciate you not to be redundant. So, Mr. Hernandez. So you're chickening out on me? Okay. Mr. Harbucks?
Thank you for your patience here today. I'm Stan Harbuck with the Better School of Building Inspection. Thank you for the opportunity to speak today, and thank you for the great public service that you all provide here as volunteers on the Texas Real Estate Commission. Just wanted to thank you, I just want to let you know that we do support this rule as is proposed, and also that we appreciate the Education Subcommittee and the full Inspector Committee's role in this and their support for those for whom their classroom is not an option, as well as the possibility that we could give us time here to transition over into these alternative means as well. We know the Education Subcommittee is aware that 1 year may not be enough for us to transition over to this. This is sort of we are to come back to them and show them progress. All the providers are expected to come back and provide them with some evidence of progress in about a year from now in order for them to reconsider extending the deadline beyond where it's been proposed to now. We've already begun our research on obtaining IDEC approval, and we certainly have set a goal here to try to achieve that as soon as possible. Thank you.
Oh, thank you. Awesome. Short time. Sir? Jones, you're making a motion? Okay.
Madam Chairman, move the staff is authorized on behalf of this commission to submit amendments to 22 Texas Administrative Code 535.212 education experience requirements for a license is submitted by staff along with any technical or non-substantive changes required for proposal to the Texas Registry for publication and public comment.
A motion to have a second?
Second.
All in favor say aye. Oh, whoa, question, slow down.
It's okay. Just for the sake of those people that are here today that weren't here previously, when we talk about the other two options, can we just explain what those are?
Ms. Lewis?
Sure. The first is the option that for their, not the additional education, but for their substitute experience requirement, they would complete, for the fieldwork portion, complete 40 hours of fieldwork through a ride-along inspection course. And I will note that the ride-along inspection course that is tied to the continuing education allows for 2 students, but in recognition of the need for schools teaching in a pre-licensure situation, to have a larger class, they did allow up to 10 students per session, and then 24 hours of approved classroom or alternative delivery interactive experience. The second option, if they're not able to find a ride-along instructor or course, would be that they could complete 16 hours of a commission-improved live interactive webinar session that meets all the other requirements of a ride-along course. In other words, it's going to be a live webinar going through a home, doing a full home inspection. And then the exception to that is they could have up to 20 students in that session. And then they would have to take 80 hours of an approved classroom or alternative delivery interactive experience module. Again, recognizing that you're going to need more remote learning than you would actual hands-on in a smaller class. So there's a sort of a striated system in place. And then the third option is the one is what's always been there, and they're leaving it there for a year for transition.
So we're looking at scaling the opportunity for interactive distance learning based on the amount of people that are in the class.
If it's a hands-on class, you're actually physically present in the house with the instructor.
Correct.
10 students, they feel that's a more valuable learning experience, so they're not requiring as many additional alternative delivery interactive course modules than if you're just doing a webinar. You're going to need maybe a little more coursework.
I would just like to state that I understand why we're looking at doing this, but I would also encourage the commissioners to realize that human capital is one of the most important elements that we have, and I want to make sure that we don't go to a full online opportunity or full online ability for someone to get their certification. So I appreciate the spirit of what's going on here. I will be voting with the motion today, but will exhibit great caution in allowing any further online opportunities.
You understand there's legislation that we're working to meet, and we're working with the industry to meet the intent of the legislature's request.
And I too will be speaking with the legislators to make sure they hear. Thank you.
Okay, motion. All in favor say aye.
Aye.
Opposed nay. Motion carried. 22.
Discussion and possible action to propose amendments to 22 TAC 535-218 continuing education. This rule also was adopted. Amendments to the rule were adopted at your last meeting in October to be effective January 1st. Since that adoption took place, there are a couple of items that the committee felt needed refinement. This is the first time they've had a continuing education course program, so they want to make sure that they get it right. So they're bringing these amendments back, bringing new amendments back to the rule that was just adopted to increase the number of hours a licensee can take in any one subject area per renewal period. It was 12 hours, and now they're going to propose that it be 16. And also to clarify that government entities and certain nationally recognized building organizations do not have to be commission-approved providers for licensees to receive continuing edu credit for courses that have been approved by those entities.
Okay.
And staff would recommend that the amendments be proposed as amended.
Commissioner Turner?
Madam Chair, I move that staff is authorized on behalf of this commission to submit amendments to 22 TAC 535-218, continuing education as submitted by staff, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Have a motion, have a second?
Second.
Any question? What?
I will point out one more thing, that there is also a form adopted by reference which sets out the course approval form, timelines, and specific requirements for their new SOP legal ethics and update course.
All in favor say aye.
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 Opposed? Motion carries. Agenda item 2.3.
Actually, I'm going to let Ms. Warman present this one.
Okey doke.
She worked with the committee on this.
Yeah, 23 is apparently some kind of placeholder, and then we got 24 that seem to be the same thing.
Yeah. So I don't think there's no action on, I'm sorry, that's right. On 23, there's no action, so we can, that was something that was on the agenda as a placeholder, and the committee didn't bring anything forward, so now we'll go to agenda item
So
24.
there was a fake us out.
We're faking you out.
Okay, so let's go with 24. Thank you. The new kid picks it out.
Kristen Warman, Deputy General Counsel to the Commission. On agenda item 24, discussion and possible action to propose amendments to 22 Texas Administrative Code 535.223, Standard Inspection Form, Report Form. The proposed amendments are recommended by the Texas Real Estate Inspector Committee to notify consumers that an inspector may include contractual terms or attach a service agreement to the standard form, and to clarify that an inspector may change the standard form as necessary to allocate additional space for comments in the additional information provided by inspector section and in the sections for each inspected item. There is also a form that is adopted by reference, Property Inspection Report Form REI 7-4, that is used in reporting inspection results. That form was revised to add a notice to the consumer that although the inspector may include contractual terms in the attached form, the Commission does not regulate contractual terms between the parties, and consumers should consult an attorney if they do not understand those terms. Staff recommends that the amendments be proposed as presented.
Okay.
Madam Chairman,
Yes, ma'am.
I move that staff is authorized on behalf of this commission to submit amendments to 22 TAC 535.223 Standard Inspection Report Form and the standard form adopted by reference as submitted by staff, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Have a motion to have a second?
Second.
All in favor say aye.
Aye.
Opposed, nay. Motion carries.
Agenda item 25 is discussion and action to propose amendments to 22 TAC 535-231. The error that we had in the numbering that we just adopted by emergency rule, we still have to go through the process of regular proposal and adoption, so we would recommend that this amendment be proposed as presented.
Okay. Commissioner Martinez, you want to do this?
Absolutely. I'm going to move that staff is authorized. That the staff is authorized on behalf of the Commission to submit amendments to 22 TAC 535.231, Standards of Practice, Minimum Inspection Requirements for Plumbing Systems as submitted by staff, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Motion to have a second?
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 26.
26 is discussion and possible action to propose amendments to 22 TAC subchapter F for section 535.62, acceptable course of study, and 535.64, obtaining approval of a offer a course, and this is to propose amendments to add real estate finance as a new subsection for a 30-hour course with specific topics and subtopics mandated and with mandated time periods that the instructors must follow. The addition of F requires relettering, and then section 535.64 adds a new subsection to adopt by reference the course approval form for real estate finance. This is being brought forward by your Education Standards Advisory Committee, and staff recommends the rules be proposed as presented.
Commissioner Hensley.
Madam Chair, I move that the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC 531.1, Fidelity 531.2, Integrity 531.
With this, the wrong one. Agenda item 26.
Oh. Excuse me.
You were going to
Start
take on the
again.
big one.
Sorry.
Start over again.
Madam Chair, I so move that the staff is authorized on behalf of this commission to submit amendments to 22 TAC 535.62, acceptable courses of study, and 535.64, obtaining approval to offer a course as submitted by staff, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Is there a second?
Second.
All in favor say aye.
Aye.
And opposed, nay. Motion carries. Item 27.
Okay, actually, the next three agenda items come forward to you as a result of our comprehensive rule review that we do every 4 years, and staff is recommending that amendments be proposed for sections 531.1, 531.2, 531.8, and 531.19. Some of these are correcting typographical errors, others are changing the word licensee to license holder for consistency of terminology throughout our rules. And a lot of it's just, for this section, it's just restructuring for clarity. There's really no substantive changes. And staff would recommend that they be proposed
Mr.
as
Turner,
presented.
would you take a second chance at that?
Madam Chair, I move that staff is authorized on behalf of this commission to submit the proposed amendments to 22 Texas Administrative Code, Section 531.1, Fidelity, Section 531.2, Integrity, Section 531.8, Consumer Information, and Section 531.19, Discriminatory Practices, as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
A motion, have a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries. Ms. Lewis?
Okay, the
58.
next chapter is Chapter 533, with Practice and Procedures, and there was a little bit more substantive changes made to the sections in this chapter based on a comprehensive review. There are new subheadings included. There are clarification of terminology, rewording, and adding certain sections to expand what was there for clarity for the commission, the public, and respondents counsel. I won't go through all of them, but if you look at your materials, the additions are in blue, the deletions are in red, and these are at this point just being proposed for comment, public comment.
Mr. Jones, are you on the page?
I am. Madam
well-
Chairman, I'm sorry.
Go ahead.
Madam Chairman, I move the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC Chapter 533 as presented, along with any technical or non-substantive changes required for proposal to the Texas Registry for publication and public comment.
A motion, do I have a second? Second. All in favor, say aye.
Aye.
All in favor, say aye.
Aye.
Okay, I only heard one aye. And opposed, no. Motion carries. Agenda item 29.
Again, this is revisions being suggested to Chapter 534 after a comprehensive rule review. And for the sections listed there, there were some revisions made for greater clarity and consistency of terminology, correcting sites, and correcting a rule citation. Again, the proposed changes are in blue and proposed deletions are in red. You will notice, I'll just point this out because you're going to see this over and over again, that one of the terms we're changing is commission. When we're referring to this body, we want it to be capitalized, and when we're referring to the payment of money, it will not be capitalized, and that actually will help people who want to do online seek and find searches without getting every other rule, because the word commission is in a lot of them.
Commissioner Hensley?
Madam Chair, I'll get the right one this time, promise. I move that the staff is authorized on behalf of this commission to submit the proposed amendments to Chapter 534, General Administration, as presented, along with any technical and non-substantive changes required for proposal to the Texas Register for publication and public comment.
Motion, do I have a second?
Second.
All in favor, say aye. Aye. Opposed, no. Motion carries. Agenda item 30.
At this point, we would like to propose the new chapters be opened for the comprehensive rule review process according to the plan that was submitted to the commission in October, and that would be chapters 535, general provisions, and chapter 541, rules relating to the provisions of the Texas Occupation Code, chapter 53.
Commissioner Martinez, are you on this one?
I am. Therefore, I'd like to make a motion.
Perfect.
Staff is authorized on behalf of this commission to submit the proposed rule review as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
A motion to have a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries. Agenda item 31.
And I believe
I got that.
Mr. Olmixon has this one.
Commissioners, when I raised the, inappropriately or incorrectly, in error, raised the possibility that we might have to assess our license holders to replenish the recovery trust account on an accelerated basis. We immediately went back, of course, to the statute to look at the provisions that would guide such an action. In reviewing the statute and in accordance with the discussions that the commissioners have had on multiple occasions, looking at the amounts and the characteristics of claims that have been paid by the recovery fund, it became apparent that it would behoove this body both to review the statute for potential amendment and also some additional guidance to be placed in the statutes, perhaps restrictions on the kinds of payments that might be appropriately paid, instructions to the court, if you will, the kinds of claims that should be paid, appropriately paid from the recovery fund. And so it is the recommendation of the staff that this topic, the recovery funds, be assigned to one or more of the committees of this body for some intense review and discussion prior to the next meeting.
Thank you, Mr. Olmixon. Now I was going to suggest that we ask the executive board to take on that job.
All you have to do is sign it.
So we have done, so it shall be written. The executive board.
Executive committee.
Executive committee, take care of that. Agenda item 32.
Okay, would you hand these out? Agenda item 32 has to do with this discussion and possible action to award a contract for license examination, development, and administration services.
He's working on it.
And the commissioners will be handed a one-page summary of the scoring that was done. And we went through a significant request for proposal, and our purchaser, who would normally be here to answer all of those detailed questions, has been out because of a family emergency, and so I apologize. I will attempt to answer any questions that you do have. But in any case, we had two respondents to our request for proposal. We went through and all of the division directors were given the opportunity to review and score each of the proposals. That was done individually. And then we came together to discuss amongst ourselves anomalies, rationales, point out things that we saw, essentially defend, if you will, our particular scores, or ask questions about scores that had been. Everybody got to see each other's scores for the first time at this initial discussion. And then we went back and gave everyone the opportunity to rescore based on information that had been brought forward during those discussions. And so you will see across the top says the initial scoring with the tabulation, and you'll see the combined points of evaluators in the third column from the end, in the last column on that row. There was only 11 points out of a total of about 2,400 points difference between the two. These are the two major players in this industry. I liken it to, say Ford and Chevy, or Chevy and Toyota, or something. It says, you need a car, go get one of these. Which one do you like better? There are lots of both of them provide all of the essential services that we were looking for. So in each area, it's a matter of nuance. The rescoring was accomplished by individuals after that discussion, with no further, input
No one was directed that no one had to change scores or anything like that. All of the combined points of evaluators, as you can see, raised the spread just slightly. So there's now a 45-point differential between the highest and the lowest, or the two responses. There were two areas that had, or with respect to scoring, there were two areas that probably had the largest impact, if you will. But all of these documents, the individual scoring documents, comments, and those kinds of things it is all obviously a public record. So I need to spend a lot of time looking at those. But the other thing that I did want to point out to you, if you look at the two bottom, the bottom set of data there are the proposed exam fees under the RFP. And you will see that for brokers and salespersons, Pearson VUE, this is a combined fee of $54. PSI, their best fee after a best and final. Both of these were given the opportunity to improve, offer a best and final. Both of them did respond to a best and final. Both of them altered their fees, and then Pearson VUE also altered some other things about additional time and resources given to transition and contract administration. So, back to the fees. $54 for a real estate exam, essentially. Pearson VUE, PSI, $67. For an inspector exam, $220, Pearson VUE, $235, PSI. Appraiser, Pearson VUE, $54, PSI, $130. So in each and every case, Pearson VUE offered the lower fee to exam takers. All of this does include a $10 fee that is collected and remanded back to the commission and or board for its administration of this process as well. So, and there, as you can see, with the estimated annual volume of exams that are taken based on 2013 estimates, the differential is a significant dollar amount at $13 difference for every real estate exam, $15 difference for every inspector exam, and $76 difference on every appraiser exam. So it is staff's recommendation to the commission to award a 2-year contract with 2 options for 2 additional extensions to Pearson VUE, commencing September the 1st of 2014, subject only to the appropriate documentation that would be required by our purchaser to perfect the RFP.
Commissioner Jones?
Madam Chairman, may I move that the commission authorize the staff to complete the contract, sign the contract effective September the 1st, 2014, subject to the conditions Mr. Olmixon laid out to Pearson VUE for the exam, what do we call it, License Exam Development Administrative Services.
Second. A motion and a second. Are there any comments or questions from any commissioner? All in favor say aye. Aye. And opposed, no. Motion carries. Agenda item 33.
Thank you, commissioners.
A new face. Back.
Good afternoon, Melissa Huerta, Director of Staff and Support Services. This agenda item is the investment policy for the agency, and it's the same one that was approved last year by the board. It is our monies are invested by the state, the Treasury Safekeeping Trust. So our monies, our cash is held in there, and it's invested based on the Texas Government Code, Section 404.024 and 404.106. The staff has no recommended changes. So if there's any questions, does anybody have any questions on the policy?
Sorry, I have a repeating question. But just for the record, we are currently bound by legislation on how we can invest our money.
Yes, sir. The monies have to be held within the safekeeping trust, and they have the investment officers in there who invest our monies.
Thank you.
You're welcome.
Mr. Martinez, as a member of the Budget Committee, did you want to make this motion?
For us to direct our own money? Yes, ma'am. I'll be glad to make and second that motion.
I think there's something procedurally wrong with that. To maybe approve the investment policy as presented.
And I would like to make the motion to approve the investment policy as directed and as required, unfortunately.
Motion. I have a second?
Second.
All in favor say aye.
Aye.
Opposed, nay. Motion carries. Thank you, Ms. Huerta.
Thank you.
Agenda item 34.
This is discussion and possible action regarding the agency strategic plan for fiscal year 2015 through 2019. You have these? Okay. You are receiving the draft of the announcement that will go out once we have finalized the dates and locations for a couple of missing. We have commitments from all of the players on there, San Angelo, Arlington, Houston, San Antonio, El Paso, and Austin Board of Realtors, and many we have dates and times already set. There are some we're waiting for final confirmation. As soon as we have those, this would set the locations and schedule for our strategic planning listening tour. This would go out to the public in the form of a news release. It'll go on our website as well. All of our policymakers and stakeholders are invited and encouraged to come to one or more of these sessions and make their wishes known. We also have a guide set of questions which has been published and provided to all of our policymakers with an opportunity to have some input on those. So we have those guide questions. There are a couple of minor tweaks that we will recommend based on some input that we have from commissioners and board members. But the staff recommendation is for the commission to approve both the schedule and subject to finalization and the guide questions as well for this year's strategic planning listening tour.
Mr. Turner.
Madam Chair, I move that we accept the schedule as presented with the potential for changes as necessary, and along with that, we approve the proposed questions for the strategic plan input meetings and listening tours.
Motion to have a second. All in favor say aye.
I also move that Commissioner Martinez be required to attend each of these meetings to present his beliefs on. I withdraw my motion.
Motion dies for lack of a second, but the other one passes.
I do need opportunity to respond since I do serve as a public member to this commission. I would be willing to do so in the interest of the public safety.
Here's what I would ask all of you to attend at least one of them. It's a good process, and I hope that we have one or more commissioners at each location if possible. So if you want to get together somewhere along the way and say, I'll go to this one and you go to that one, that would be good.
Can we ask, could someone on staff help us coordinate that?
Absolutely. If you will let me know, send it to me or send it to Christine Anderson, who is coordinating all of this. We welcome you to as many as you can make. Obviously, if somebody wants to fly to El Paso, we'll probably limit that to 1 rather than 5 folks going to that one.
Can't have 5.
Things like that. Yes, sorry, we can't have 5 anyway.
Never
That
have
would
5
be
anywhere.
that's true. That's true. The last thing I wanted to just assure the commissioners on this is that these questions will also be on our website and a capture tool available, so anyone who cannot for some reason make it to any one of these can still make their input known to us via answering the questionnaire on our website.
Thank you, Mr. Olmix. And also, if any of you are addressing any large audience of real estate consumers or real estate licensees, anywhere that you are, you might suggest to them, talk about this, tell them it's online. If they can't attend a session, they could go online and answer the questions and send them in, so we would have that input from as many people as we can get input. Thank you so much to Mr. Olmix and to you and the staff for this process. We really, really like it. Agenda item 35. What is that all about? Who's that? Ah, Gwen. I mean, Miss Jackson.
Old face.
Just a good face.
Agenda item 35 is discussion and possible action to approve Form EDCA-2, which is a real estate course application form, which is to revise that one, and to add new form EDICE CA-0, which is an inspector continuing education course application form. The reason for these forms are the EDCA-2 form previously included check boxes for inspector continuing education course applications, and that information is no longer needed because now that the inspector education has its own program now, we'd like to have a new form for them to use to submit their continuing education courses to us, which is the EDICE CA-0.
Thank you.
Staff recommends that the forms be approved as presented.
Commissioner Hensley?
Madam Chair, I move that the Commission approves the changes to Form EDCA-2 course application and new Form EDICE-CA-0 Inspector Continuing Education ICE-course application as submitted with any technical and non-substantive changes.
A motion of second?
Second.
All in favor say aye. Any opposed, no. Motion carries. Thank you so much, Ms. Jackson. Agenda item 36 is the, just to point out that our next scheduled meeting is on April the 28th at 10 o'clock in the morning, and I guess a proposal for the next meeting to be on August the 18th. Is that what you're giving me?
That's the default third Monday. Madam Chair?
Yes, sir.
In relation to the recovery fund topic that we had earlier today, will we have any subcommittees prior to that next meeting that we need to announce at this time?
The Executive Board is going to look at that and
Okay, got it.
talk about that after the meeting, just for a quick minute, I think, see what we're going to do.
Okay, thank you.
What was the proposed date for August?
August 18th, April 28th is set. August 18th is proposed. Is that correct?
That
That's
is
right?
correct.
Okay. While you guys are checking your calendar, I just wanted to tell, I think I have like maybe 2 people in the room that care about this anymore. We are aware of the gas pipe issue that has come up in the world and the request for action by some of the inspector community, and the request came at a too late a date to get onto our agenda. This item has been sent on to the inspector committee, and Mr. Olmixon is working with those guys to come back with some proposals at our next meeting. Just want you to know we got it, we know about it, we can't do anything about it today. How does August 18th look? No way I can look at mine. Give me a chance. And the next one after that would be November the 17th, if you want to also look at that. I think Commissioner Martinez volunteered to bring turkey.
I will, since it's 10 days after my birthday. Yes, ma'am.
We had a big crowd for Thanksgiving this year, and we had a bouncy house. So
You could bring a
maybe we
bouncy
can
house.
bring a bouncy house.
Right. That might really make the meeting a lot more entertaining. Okay, I hear no. Stop it. I hear no objection to the proposal for the future meetings. If there is no other thing to come before this body, we stand adjourned at 2:30.